Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Hey everybody, it's Squid. Welcome back to my channel. Let me change the picture so I don't look like rackets. What the hell? Whoop. Apparently I'm gonna look like rackets for the day. Well, that's fun. I don't know what they did, but yay. How is everybody doing today? Let me see if I can. I have no idea what goes on with why with why freaking YouTube does what they or StreamYard does what they do, but yay. Yay. So here we are. Totally not totally not understanding why it's all weird. But sometimes I don't understand like what happens with StreamYard. I don't sometimes, make it make sense. I just I don't know. I stop asking questions with this. Yeah, it happened to freaking Ricada earlier. I was watching and Ricada was like on half of his screen, and it was like it was weird because it was Megan had to tell him, and it was like he was like this, and it was like, oh, but that's still weird that I'm like half the size of that I normally am. So let's do some editing here. Wee. Wee. I don't know if y'all can see what I see, but it's funky looking. There we go. Save. Save new layout. But I don't know. It's freaking weird. Welcome to welcome to StreamYard and YouTube getting into arguments every day and shit changing every day. Oh, hope everybody is having a better day today and processing what has gone on in the last 24 hours. And remember that today is the 24th anniversary of the worst day in modern American history. Modern, I'm not saying of all time, so before anybody comes at me and hates in the comments, modern American times, because remember, we have people that are old enough to drink that were not alive on September 11th. I was a sophomore in high school because I am old, but that's just me. Uh, I've been trying to figure out why my phone is talking when I type. LOL, I'm going crazy. Try going into your settings and going into accessibility. Sometimes things in there get tweaked with updates and stuff, and sometimes things can yay. Now I'm not sure how much I can see, then I have to switch to replay, but I'm really interested in this case. Okay, so those of you who were not on my channel or not around or did not watch that trial with us, this is Carly Gregg. This is I believe she was 14 at the time. She unalived her mother and attempted to unalive her stepfather. Open here comes the lid. So with that, she did it with a pew pew. They had footage from their security camera in their kitchen, and she can be seen hiding the weapon behind her in the camera. After you can hear it on camera, you can't see it, thank God, but you can hear her mother being unalived on the security footage from their kitchen. Once again, a teenager, permanent actions for temporary problems. She had supposedly had mental health problems, changed medications, did all this, did all that. The weird thing is even though her stepfather was shot, she tried to unalive him. She got him in the shoulder. Think about the relation with when you're fighting over a weapon, the shoulder to the head, how close he was to losing his own life, has been one of this girl's biggest supporters. Her lawyers were a personal injury attorney and a DUI lawyer. No offense to DUI guy. This is nothing personal against DUI lawyers because I'm not even a lawyer. So who at a certain point, who am I to talk? However, a personal injury and a DUI lawyer trying a underage person's unaliving case being tried as an adult. It did not go well. This was Judge Arthur in Mississippi. It really did not go well. He was pissed quite a few times. He was very angry at both sets of lawyers, the prosecution and the defense team, for wasting the jury's time. This is one of my favorite judges. However, her lawyers were quite adamant about appealing straight to the Supreme Court of Mississippi due to the fact that she is underage, being tried as an adult. And here is my ethical concern with this. And this is my same ethical concern with any other underage defendant who is tried as an adult and found guilty. Yes. Yes, this is the pregnant pause judge. Yes, this is the pregnant pause judge. Judge Dewey Arthur. She is being held in solitary, which, because she's was tried as an adult and she was convicted now of first degree unaliving, hold on, I have to respond to one of my old professors was messaging me. All right. So this is my problem with underage defendants. Yes, I agree with them being tried as an adult because unaliving someone is an adult action. It doesn't matter if you're 13 or 83. Unaliving someone is a very, very serious thing, as we learned yesterday and we saw. And side note, even though that video yesterday of Charlie Kirk being shot is very graphic, it's kind of one of those things where I think everybody needs to see it for this reason and this reason only. It puts into perspective when you are talking about, I think this person should be blah, I think this person should this, I think this person should that. It puts into perspective what that actually looks like. And it's not some hyperbole on the internet where it's all fun and games and it's entertainment and stuff. It's real. It puts it into the fact that it's real life. So, hey Calvin, how are you? I was working on a roof of a house across the bay in New Jersey with the view of the World Trade Centers. I can't imagine. I was living in Kentucky at the time, and I was in freshman algebra. I remember specifically because a bunch of teachers, not one, like 3 or 4, came in to talk to my algebra teacher because we lived. It was the time when everybody was starting to get TVs in their classrooms, but they were like the big 2 TVs on the wall, and they were only like 20 inches. But I lived by the Toyota plant, so like Toyota paid for everything. Toyota built a new school in that town. So we had TVs, and my algebra teacher was like, "No, school first. Like, it doesn't matter. It's not that big of a deal. You'll see it later. You'll see it on the news when you get home." Not realizing. So I walked. The bell rang. Went from first period English or algebra to second period English. That was it. Never did an ounce of schoolwork the rest of the day. It was TV to TV to TV to TV to TV. Everybody's glued to TV all damn day. I saw the second plane hit. Yeah, it was I can't imagine what it was like to be there. It was So getting back to this case, is there any way a case for her appeal? What could have gone wrong? So they went straight to the Supreme Court. Their biggest issue was the fact that she is being held in solitary, and it's cruel and unusual punishment, and which it's an ethical concern. What do you do with a child who has unalived somebody? You can't put them with other children because you can't put them with other children because of the obvious. If they rub off, they're a convicted unaliver. But you can't put her in Gen Pop because it's a safety issue for her being 15 now, being with adult. Like, even though she has no regard for human life, there is something to be said about not putting her for her own safety. She's bound to become somebody's bitch if she yeah. It's just it's one of those situations where there's no right answer. But this is the problem you face when you commit adult crimes as a child. It's not like, oh, he stole something, it's a petty theft or this or that. It's it's hard. And I am in the process of re-uploading the short or the live from this morning. I had to take a couple things out. I had to blur a couple things just to make sure everybody's privacy stayed as private as possible. But it should be back up relatively soon. I was going to leave it private. And then I got a couple emails saying I was watching it and YouTube took it down. I was like, no, that wasn't YouTube. That was me. So I'm re-uploading it so that everybody can see our conversation from this morning. Because I think it's a conversation worth sharing. So, meh. All right. The brief of appellant on appeal from the Circuit Court of Rankin County, Mississippi. James Murphy, oral argument requested. So, in the Supreme Court of the State of Mississippi, Carly Gregg versus the State of Mississippi. And here's the certificate of interested persons. interesting the way this is written. I haven't looked at many appellant briefs, but I think this is an interesting thing to see, in the sense of how they describe people. So obviously Carly Madison Gregg, ADAs, the DA, Dewey Arthur, the circuit court judge, her appellant counsel, Honorable Bridget Todd, lead trial counsel. She was the personal injury, I think, and Kevin Camp, trial counsel. This is where it gets interesting to me, in the way they describe people. Mr. Heath Smiley, appellant's stepfather, who was a victim of the March 19th, 2024 incident and is one of Carly's strongest supporters. His lawyer, Mr. Robert Breland, Carly's grandfather, father of the victim, Ashley Smiley, which was Carly's mother, and one of Carly's strongest supporters. Vicky Breland, Carly's grandmother, mother of Ashley Smiley, and one of Carly's strongest supporters. It's interesting the way they word this. By the way, her stepfather, even though she shot him, is still one of her biggest supporters. Like, that's going to be, it's like you're trying to emotionally sway the judge. So it's just one of those weird things to me. I don't understand it. All right. So everybody saw the trial. If you didn't, I will link that playlist in the description of the video. But we're going to get straight to the arguments, because this is freaking 67 pages. We don't need a statement of facts. They do list, this is kind of nice, they list all the cases that they're citing and what pages they're on. So this is I believe this is well written so far. So we shall see. And they're all in nice alphabetical order. It's nice to see such neatness, but we'll see how the how the actual document is written. Ooh, they even have a secondary source from Scalia, Antonin, and Gardner, reading law, the interpretation of legal texts. Interesting. All right. Brief of the appellant. Statement of assignment, properly assigned to the Supreme Court of Mississippi. So, statement of the issues. Issue 1, trial court committed reversible error by giving the sentencing instructions as to counts 1 and 2 that were improper under Mississippi Code. We don't care about Mississippi Code. It's there if y'all want to see it. This document will be in the Discord if it's small enough. Discord has issues with size of documents. That's why some things aren't there. I have them, but anything over like 30 to 40 pages, it's too big. Issue 2, Carly's sentence of life imprisonment without parole as to count 2 is categorically unconstitutional. This one we're going to have to see what their argument is, because life in prison for unaliving your mother doesn't matter if you were 14, 15 at the time of the trial. You were charged as an adult. The only thing that seems unconstitutional is she can't get the death penalty, because the Supreme Court of the U.S. had ruled that the death penalty for those under the age of 18 is unconstitutional. The trial court erred by not conducting a Miller hearing to determine eligibility vel non for life without or with the possibility of parole as to count 1. And she had a plea deal, by the way, and she did not take it. So, hey, Carmen. Hey, Squid, just wanted to stop in real quick and say hello. Hope you've been doing well. How are you doing? Carmen is a spawn of AJ. If you don't know who AJ is, AJ's alternator. And if one of y'all could put AJ's link in the chat, that would be great. She does a lot on her Discord. People are very active in her Discord. My Discord is boring. AJ's Discord is fun. Issue 4. The prosecutor made improper and highly prejudicial comments during closing arguments relating to parole eligibility. I don't see this going well. I don't see this working. But hey, that's just me based on what I saw. The judge took every precaution to make this as appeal proof as possible. And remember, appeals are not about the facts. They are about the law and the interpretation of the law. They are not about guilt or innocence. It's only about what the procedural issues are. Issue 5, to the extent that Carly's sentences is to be construed as life without parole. Okay, I had to think about that one for a minute. There was a time that the judge stopped everything, and he ruled against the defense, because he ruled against somebody, but he was like, there is no case law for this. Please appeal this. I have to rule on the side of caution because there is no case law. So he basically said, I have no case law for this situation. I don't think this is the right decision, but appeal it because maybe then we'll get some case law. So he was very, very by the book. To the extent that Carly's sentences is to be construed as life without parole as imposed by the jury, the sentence was against the overwhelming weight of the evidence and should be set aside. Don't think that one for a second. It was recorded. You heard it. And then she not only did that, she called a friend and said, have you ever seen a dead body? She was that girl. Part 2, Carly was deprived of a fair trial. Issue 6, the trial court committed reversible error by prospectively denying any request for continuance without evaluating the circumstances that might arise during the proceedings. 7, trial court erred by compelling psychiatric evaluations absent the findings required by MRCP 12.2 and 17.4, thereby abusing its discretion and depriving her of a fair trial. 8, the trial court erred when it allowed Rebecca Kirk to summarize the book Crime and Punishment over objection of defendant. Issue 9, cumulative error requires reversal. All right, we're just going to highlight some of this. I'm not reading the whole thing. If you want to see the case or any case documents, I have a whole Carly Gregg playlist with the trial being streamed and pretrial hearings. Appeal proceeds from Circuit Court of Rankin County. Count 1, first degree unaliving, sentence of life imprisonment. Count 2, attempted first degree unaliving and sentence of life imprisonment. Count 3, tampering with evidence, sentence of 10 years. She put the camera in the freezer or in the refrigerator. She put it somewhere. She hid it, thinking that the cops wouldn't look in the refrigerator. On or about May 22nd, 24, Carly Gregg was indicted on first counts of those counts. Carly's trial was September 16th through September 20th of 2024. The jury returned guilty verdicts on all 3 counts, fixing punishment at life imprisonment, counts 1 and 2, while the court imposed sentence on count 3. Aggrieved by the judgment of conviction of sentences imposed, Carly now appeals to this honorable court. All right, that's the statement of facts. I'm not going through all of the facts. We know what they are. We watched the trial. She unalived her mom. The jury found that to be fair. But I will read this part about Kirk. Kirk testified she saw Carly on March 18th, the day before the incident. Kirk testified that this was the visit was focused more on Carly's mom than on previous sessions were focused more on school. Kirk also opined at this session that she considered whether she was serving her the best I can based on the apparent inability to get Carly to open up. She's a teenager. If you can get any teenager to open up, good luck. When asked if she believed that Carly loved her mom, Kirk testified, "Yeah, I believe she did." She further testified that Carly seemed sensitive to her mom's feelings and didn't want to hurt her mom's feelings. Kirk was questioned about treatment notes, saying Carly will read Crime and Punishment. After Kirk had said Carly was reading The Castle, which Kirk herself did not know very well, and had mentioned The Bell Jar, it's a bunch of books. The prosecutor then asked Kirk to tell us what Crime and Punishment was about. Defense objected at sidebar as irrelevant, unduly prejudicial, noting Carly had disclosed she had not read the book. The court overruled the defense's objection and allowed the prejudicial testimony. Here's the thing. I didn't understand that objection because it wasn't about her actually reading it. It was about why she prescribed her to read it or recommended she read it. When every time your therapist recommends something, they recommend it for a reason. And in my opinion, she was asked about it as to why she recommended it, not to say that Carly was going to do what was in the book. Kind of a situation. But hey, in front of the jury, Kirk delivered a lurid synopsis describing a psychopath student who plans a hatchet murder. Kills 2 people, writes about why they kill people, and is declared insane and serves 8 years unrepentant in a Russian labor camp. She then admitted her underline of the title in the note was just for grammar, not clinical emphasis. Which, grammatically speaking, you'd underline titles. Grammar. Hello. And conceded the note reflected Carly had not yet read the book on 2/21 and that she only thinks Carly read it later over spring break. The footnote: in arguing to allow Kirk's testimony about the plot of this book, the state argued that the book was important to Kirk's counseling session, so important that Kirk underlined it. However, Kirk revealed that the only reason she underlined the book was based on the fact that it was the title of a book. I mean, that was dumb. Like, and Heidi, thanks for being one of the best mods ever. Olivia Lieber, a psychiatric mental health nurse practitioner at Precise Mind, also testified during the trial. Lieber testified that she evaluated and managed Carly Gregg across 3 encounters in the 2 months preceding March 19th, January 15th, February 14th, and March 12th, with Ashley Smiley present each time. Lieber explained that while the minors may speak alone, confidentiality is limited when a parent is in the room, and she can treat only from what is disclosed and observed. At January 15th intake, Carly presented to Lieber for depression, anxiety with social stressors tied to family conflict and a recent altercation with her mother. Screening forms indicated ADHD checklist and modified mini-screen reflected no hallucinations, and Lieber's mental status exam documented orientation ×3, generally name, time, and place. Their name, name, date, and location. Normal speech, cognition, memory, judgment, insight with no psychosis. She diagnosed adjustment disorder with mixed anxiety, depressed mood, and major depressive disorder single episode. Moderate started Zoloft. And this is where the medications were interesting to me because SSRIs under the age of 18 have different effects. And when you have people under the age of 18 on different medications, psychiatric medications at that, hormone medications, anything like that, it can affect the way they think. And it can affect their actions, sometimes not so good. So this was leading me down the rabbit hole of researching school self-deletions and school deletions. If you know what I'm getting at, YouTube, don't hate me. And the effects of what these children or young adults who were doing these school deletions were if they were on SSRIs and how long they had been on them. That is a rabbit hole. Yeah? Yeah, you got a pretty dress on. You want to see? Oh, do we? Okay, come here. Oh my goodness. Hi, Mommy. Hi, baby.
Ow!
Oh, yeah. Mommy. Hold on. Mommy. Y'all, we need an intermission. I have to go do mama stuff. I'm going to take care of you, baby. I will be right back. Got to do mama stuff. If you know, you know.
Our hearts beat to the city streets. We began to feel the fire. We rise like tall buildings as the chemicals they take us higher. The night's young and it's just begun as she puts her hand in mine. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just two hearts running wild. Never sleep, never stop, as we shout from the top. We're gonna be two hearts running wild. Now the morning is the afternoon. We lay awake in bed. The glass so loud as the hours pass. We're gonna do it all again. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just two hearts running wild. Never sleep, never stop, as we shout from the top. We're gonna be, we're gonna be two hearts running wild. Summer sky, it was the best we ever had. And we'll stay young forever. We'll never have regrets. We wanna chase the night, wanna dance to the light, pull the stars from the sky, just two hearts.
Thank you for your patience with me. I appreciate you guys so much. Let me get rid of that banner. Whew. Small and mighty. Oh, yeah. All right. Where were we? Talking about teenagers and SSRIs. The rabbit hole of school pew-pewers with unalivers or with SSRIs is a rabbit hole that not even Spawn and I have the time to, or the mental capacity. Yeah, deep rabbit hole. Oh yes, SSRIs are fun as an adult. However, yeah, and I believe Zoloft is an SSRI. So yeah, and it's kind of wondering if, since they're not recommended for kids, and yet you gave it to somebody who was 14, if that caused some issues. So I have this issue with like, yes, I believe she's guilty. Yes, I believe you know right from wrong. But at the same time, there were certain things of like, there were certain issues where I was like, this is a fine line. So, you know. All right. And Moderate started Zoloft 25 milligrams and provided the standard SSRI black box counseling about possible increased self-deletion thoughts and need to seek ER care if they occurred. February 14th, Carly reported little effect from 25 milligrams, denied self-deletion or other deletion, ideation, and auditory and visual hallucinations. Footnote 2, and the dose was increased to 50 milligrams, which is what I think is normal. Maybe a lot for a kid, but generally speaking, it's kind of a normal titration up. On March 12th, Carly reported feeling like a zombie on Zoloft. Lieber directed a cross taper off Zoloft and the initiation of Lexapro, 5 milligrams. I think this was where I had the problem. Not a doctor, not a psychiatrist, not a psychologist. But this, I understand the cross tapering down on one while increasing or starting another one. I've done it plenty of times, but I've also done it talking to a therapist weekly to see how I'm doing. She was seen once a month, January 15th, February 14th. So during this cross taper, and then March 12th. So from February 14th to March 12th, she had nothing. She started this cross taper, and that's when things went weird because the incident was March 19th. So she had 7 days of this cross taper. But I don't remember if she was being talked to weekly at that time, if she had said, hey, let's meet tomorrow, let's meet, call me if you have any issues like this. Also, a teenager, especially somebody new on meds, was 40 years old. I've been on meds for a good 20 years now. It's different for me. Like we as adults, we've done this enough where we know what kind of happens and how things kind of work. A child doesn't know. They just don't have the experience to know when a medication is affecting them a certain way. And how do you know what's the medication and what's just being a teenager? I have problems with with kids on medications for this. This is a number of reasons, but this is one of them. This is the big one. Again, finding Carly oriented with normal memory, judgment, and denying all the ideations. While noting she cannot know whether a patient is fully adherent to instructions. And that's the thing. As a doctor, as a therapist, as anything, you can give a patient instructions and you don't know if when you're not with them, they're left to their own devices. Sometimes it goes great and sometimes it goes to shit. You never actually know. You're not there to hold their hand. Footnote 2, however, Lieber admitted in cross-examination that it's fair to say that patients don't always report everything to their providers. Yeah. Same here. It's good, especially these types of meds for peds. Yeah. I feel like for medication and pediatrics, like you need to be checking in daily because hypothetically speaking, if she has been found guilty, so there's no allegedly anything. So say between February 14th and March 12th, you checked in on her and say March 1st. Say you checked in on her and you found out that she was feeling like a zombie, you could have changed this medication earlier and maybe not had whatever happened. That's hindsight being 2020, and it's only a hypothetical, but it's one of those what if situations that what if you checked on in every 2 weeks or weekly instead of monthly? And like I have a problem with only being seen once a month if you're a teenager on a medication. You need to be checked in on by your med staff whether it be mental health or physical issues, more than once a month until that medication is like it's different for someone who say have chronic pain. Say you have like CP and you know that you've had CP since you were born. You kind of know how to manage. Okay, you only need to check in with your provider once every, however often you guys decide is appropriate because you've dealt with it for a long time. It This is a problem to me. Then this will never be, even though I think she's guilty of sin, this right here will always be my problem with her case. And I can't there's certain things that you get stuck on. This is one. Ugh. I'm hearing a bunch of hypothetical torts from negligence of specialists. Yeah, and it was just weird because it is just the medication to me was a big thing. What side effects was she having that made her was the medication causing her to go a little, or was it her personality and the medication was just masking it and this was going to happen no matter what? It's those questions we'll never actually have the answer to, but it's those questions that I ask myself as a provider. I did not deal with medications. My best friend is a nurse. I am not. But OTs do work in mental health. So, and my professor, the one I was talking to, said you can always take the mental health or the phys rehab out of mental health, but you can never take the mental health out of phys rehab. So, knowing your mental health and knowing how to manage people's mental health is vital to my job. On cross, Lieber testified that she had known Carly was hearing voices. If she had she known Carly was hearing voices, I feel like that was worded really could have been worded better, just for ease of read. She would have reconsidered the diagnosis and considered an antipsychotic because hearing voices indicates psychosis. And this is another thing. Was Carly really hearing voices? Because she never reported it to anybody else, including her mother. Was she hearing voices to get attention from her? It's one of those, or was she claiming psychosis? Because she did try to plead insanity, and it did not work. She agreed SSRIs carry a black box warning for increased self-deletion thoughts and acknowledged patients sometimes do not disclose everything, and read that Ashley Smiley declined Prozac because it had previously given her unaliving thoughts, self-deletion thoughts. The family history section recorded the father with bipolar disorder, ADHD, substance abuse, and Lieber agreed bipolar can be hereditary. Here's the thing. He never testified, and the only family history was a self-report by Ashley, not an actual medical record of his. Hi. Bye. Bye, baby. Dr. Amanda Gugliano, a licensed psychologist, director of the Forensic Evaluation Service at Mississippi State Hospital, and a DMH-credentialed forensic evaluator, was accepted by the court as an expert in forensic psychology. In this case, the state contacted her, and she served as a court-ordered evaluator. Her report was filed with the clerk for distribution to both sides. During the interview, Carly admitted vaping marijuana but declined to answer whether she had abused prescription medication. Gugliano also testified that Carly reported having experienced reactions in discontinuing one psychiatric medication and starting another in the week leading up to March 19th. There's the kicker right there. This is what made me think maybe the medication had something to do with it, but I don't think she was insane. If that makes any sense. Because you don't have to be, you can have a mental health disorder, have self-deletion or other thoughts, but not be in a state of psychosis. Because medication affects withdrawal had become a potential issue bearing on the sanity at the time of the offense, and that topic is outside her specialty, Dr. Gugliano did not render a sanity opinion and recommended that a forensic psychiatrist conduct the aspect of that evaluation. Boy. Dr. Jason Pickett testified as a retained expert on behalf of the state. On direct examination, he explained that he is an ER physician, a general psychiatrist who completed a forensic evaluation fellowship, forensic psychiatry, fellowship in June of 23 and became a board certified in forensic psychiatry around September 2023. This is where it got interesting to me in the sense of they tried to discredit him. He has worked forensic cases since July of 2022. He made it clear he is not a child adolescent board certified, and while general psychiatry residency included some pediatric exposure, this matter is his first adolescent forensic evaluation. Gotta have a first time for everything. He further acknowledged this was also his first time testifying in a criminal case. This, I did not understand why that had anything to do with anything. Oh well, if it's your first time, your second time, your 100th time, who the hell cares? It's not important. The only thing it might be important to is how nervous he is. Hey, Carmen. Sorry, my mom called right when I commented. We've been doing well. I try to swing in whenever I can. Glad you're doing well. We're doing okay. Mr. Squid had some medical stuff going on lately, but we're good now. We're good now. Oh, Mr. Squid update. He is good, I think. And Unhung Hero, thank you for the 10 gifted Squid Pro Quo memberships. Always turning the chat green. Always a star pupil in here. And thanks for helping to make sure that that I get a little bit of something for the work. And I just got a notification from YouTube that says there's no issues with my video from this morning, so it should be uploaded and ready to go. If you don't specify as in pediatric psychology, then there's an issue. There might be an issue with that. My issue with their questioning was that this was his first time testifying. Like that was the big deal. So I do think that they should have found someone who specialized in child and adolescent psychology and psychiatry, but as far as them talking about this is first time testifying in a criminal case, that to me had no bearing on his credentials. He contracted his background with Dr. Clark's greater tenure than child adolescent board certification. On the substance, he explained that his opinion rests on extensive discovery, including contemporaneous video and text messages and roughly a 4.5-hour clinical interview, concluding that even assuming every diagnosis proposed by the defense expert, Carly understood the nature, quality, and wrongfulness of her acts in the time of the offense. And that right there is the key that nobody with an insanity defense wants to hear. Notwithstanding, Dr. Pickett also testified he does not diagnose Carly as a psychopath. All right. So, getting to more interesting stuff. So he is skeptical that dissociation explained the offense, stressing that he viewed as high-level, purposeful executive functioning shown in contemporaneous record. He also noted malingering of amnesia after homicides is well documented, while reiterating that he did not rely on jail-era self-reports because of secondary gain. Yeah, it's the when I read these appellate briefs, I'm like, you're putting shit in there that's not important, as to like put something in because just like when a jury hears an objection and the judge is like, okay, scratch that from the record, jury, disregard what you just heard, you can't unring that bell. So when you're putting, oh, it's his first time testifying, even though it is not an important detail, to me, it's put in there as kind of like a talk to the judge or tell the appellate court that he might not know what he's talking about because it's his first time testifying. So it's like, it's just one of those things of like, not important, but like gamesmanship. Regarding treatment, he characterized Abilify 10 milligrams as a moderate adolescent dose and questioned the logic of using Celexa after reported Lexapro issues. I think Celexa, and Heidi, you can probably correct me on this. Celexa and Lexapro are in the same class of drugs, if I'm remembering my pharmacology correctly. He also questioned the reliability of Kevin Gregg's bipolar diagnosis, citing sparse records and confounding substance use, while acknowledging that antipsychotics can be prescribed for behavioral control and are not dispositive of psychosis. Yes, they have, every drug has an alternate use. Things that used to be viewed as side effects, like weight loss, for certain drugs are now like off-label use. You have certain things that are anticonvulsants, but they noticed migraines went away, like Topamax. So, it just because somebody's on one thing doesn't mean they're on it for the main use. Sometimes they have off-label uses that they're prescribed for because a side effect can be helpful. He noted Carly appeared lucid and competent when he evaluated her on August 30th, while emphasizing that his task was to opine on her state on March 19th. He only had a brief 6-minute phone contact with stepfather Heath Smiley and did not hear Heath's courtroom testimony. All right. Here we go. The defense called at the trial Andrew Clark, psychiatrist, board certified in adult, child, adolescent, and forensic psychiatry. 28-year career split between treatment and forensic work. Longtime teaching at Harvard, MGH, and Boston Medical. Lamotrigine, mood elevator, and epilepsy treatment. Uncle Hero, thanks for a $5 super chat. I'm familiar with lamotrigine. All right. Retained in August 2024, he first reviewed the records and concluded a 4-hour in-person interview with Carly on August 29th at the Rankin County facility. Later interviewed Heath Smiley, the stepfather, by video, 90 minutes. Reviewed Vital Court jail medical records, and after his interview, although the defense moved several times to admit his written report, the court sustained the hearsay objections, and Dr. Clark proceeded to testify in the basis and methods he set are standards in the field. On substance, Clark overall impressions of a bright, book-loving adolescent who is generally dutiful, socially a follower, close with her mother, affectionate with her stepfather, and strained with her biological father. School was consistently strong, though there was a 7th grade sharp object incident that led to a semester at an alternative school. He noted the treating therapist then called it much ado about nothing. I don't really think that was much ado about nothing, but to me that shows a history of things. It worked way better for me than actual ladies. I mean, whatever works. At a certain point, it's whatever works. He recounted early trauma, death of a younger sibling, parental separation with DV, problematic visitation history with her father. By ages 6 to 9, Carly reported intrusive memories, but you notice she never reported this stuff to her actual therapists that were treating her before this incident occurred. So it's interesting how she talked about it after the fact. Like, oh, I've been having these problems since I was 6 years old. But you never told your actual treating therapist that you had these problems? Persistent unfamiliar male voice and derealization by 9 to 11, low mood progressed. Mid 12, she began cutting, using anxiety as an anxiety coping behavior. I mean, let's get to, so there was just a whole bunch about medications and that did not add up to me. So, citalopram and escitalopram Lexapro have no significant drug interactions with their low potential to inhibit isoenzyme and PEDS nursing implications is different. I will take your word for it. All right. Trying to get to the summary of the argument, because if y'all want the full facts, we can go back and watch the trial. I do have them. I did watch them live. Summary of the argument. Every judge must learn to live with the fact that he or she will make some mistakes. It comes with the territory, but it is something else entirely to perpetuate something we all know to be wrong only because we fear the consequences of being right. This case proceeded to trial on an exceptionally compressed schedule and under a series of statutory and constitutional errors that tainted both sentencing and the overall fairness of proceedings. Really? Did it really? Sorry, I push back on lawyers who have to come up with things in order to make their argument. It sounds like a story. It sounds like a fairy tale. The arguments are organized as follows. Part 1 addresses errors in the sentencing phase. Part 2 addresses structural and procedural rulings that undermine fundamental fairness. Carly was indicted barely 2 months after the incident and brought to trial within 6 months, effectively a rocket docket. Interesting choice of words. She was indicted in 2 months, but think about it. She's going to be indicted quickly because it was on video. She was the only person in the house. She had the pew-pew behind her on the chair. You heard it. You heard her walk to where her mother was. You heard her mother scream. You heard the pew-pew shots, the loud bangs. And then you heard her walk, or you saw her walk back into the kitchen as if nothing had happened, all nonchalant, and then pick up her phone. Or her mother's phone. She texted her stepfather, "What time are you gonna be home, honey?" Or something along those lines. In a case of this magnitude, requiring collection and review of extensive medical and mental health records, multiple evaluations, substantial family background history, and disputed motive, such acceleration is extraordinary in Mississippi criminal practice. Guess what? Guess what? Guess what? Doesn't matter. The compressed timeline set in motion when at the first pretrial hearing, the court announced it does not continue cases, together with the erroneous and unconstitutional pretrial orders, deprived the defense of a fair opportunity to prepare and present a constitutionally adequate case, culminated in the imposition of life without parole on a juvenile. The counsel for the state, as well as Carly's lead trial counsel, basked in the local, state, and nationwide media publicity during the course of time the case was pending, and even afterwards, appearing on numerous television interviews and internet-based podcast episodes. Further, The trial judge appeared to make decisions based on his fear of negative publicity. I don't believe that one for a second. Stating at one point, "It's not y'all's name that gets run in the newspaper if something happens. It's mine. This court is set for trial in September." I see why he said that, and I don't think he said that with malicious. I see no reason why this case can't be tried in September. Yeah, and guess what? It's his courtroom. So it's his courtroom. I don't understand how that's so hard to understand. Part 1 of appellant's brief addresses the issues with Carly's sentences. First, as to counts 1 and 2, the court used the wrong framework for a juvenile tried after July 1st of 2024 and amended Mississippi Code 97 whatever creates a juvenile specific scheme. That code authorizes the jury to fix the penalty at life, and if the jury declines, the court must impose a term of 20 to 40 years. Life without parole is not listed. Here's my problem with that. She was not tried as a juvenile. She was tried as an adult. So you don't get juvenile specific schemes when you're tried as an adult. You get treated like an adult. You get treated like an adult. I don't understand I understand that every defendant found guilty is going to try to appeal. It's their constitutional right. However, sometimes I think that lawyers just take advantage of people willing to pay to have an appeal written. Because if she was tried as a juvenile, I totally understand where this would be coming from. She was not tried as a juvenile, and I have to read the statutes to be completely certain of my position. However, just based on the way this is written, it's like that code creates a juvenile specific scheme. She was not tried as a juvenile. She was tried as an adult. So therefore, anything that is regarded to a juvenile doesn't matter except for the Supreme Court's decision on no death penalty for Supreme Court or for underage defendants. So that's seen as cruel and unusual punishment. By contrast, the 97-2C capital murder expressly gives the jury the choice between life and life without parole, or a 25 to 50-year term if the jury does not fix the penalty. Reading the subsections together and applying the canons against surplusage, lenity, and negative implication, the legislature deliberately omitted life without parole from first-degree unaliving for juveniles while explicitly authorizing it for capital murder. But is that for juveniles tried as juveniles? Or is that juveniles tried as adults? Hey, AT1, how are you? There's the kicker. Are they juveniles tried as juveniles, or are they juveniles tried as adults? You can't. I believe my first instinct is to say that they're arguing the wrong. Does that make sense? Like they're putting the wrong arguments together because she was not tried as a juvenile, she was tried as an adult. So therefore anything related to a juvenile does not matter and does not apply. I mean, I could be completely off base, but that is just my initial. Does that make sense to anybody else, or is it just me? Hey, Lurkin Meowth. How are you? She was 14 at the time. I mean, I know she was a baby, but 14-year-olds still know right from wrong. And they still know that taking somebody else's life, especially your mother's, is a bad idea. Life in 2B therefore means parole eligible life. If life already included life without parole, the distinct life without parole option in 2C would be entirely pointless and superfluous. I hate that word. I'm so bad at saying that word. Like, my brain can say it, but my mouth can't. The court's instructions on letting the jury toggle parole on count 1 were therefore ultra-virus. You got Daddy's cup from the hospital? Yeah. Oh, thank you. Thank you. You want to come up?
Yeah, I did it.
You did it?
Yeah.
You want to read a appellant brief with me? Oh, my goodness. Yeah.
Yeah, I did it.
You want to say hi?
Hi, today. My, hey.
Yeah, it's a sad day, baby girl. All around.
What is it?
Yeah. Maybe we can do something special for Charlie Kirk's daughters. What do you think?
I think this.
Yeah, what do you think? Think a good idea? High five? Yeah, okay.
I think this is it.
Yeah. And the life without parole sentence on count 2 is likewise infirm for juvenile. But she was not charged as a juvenile. I'm going to keep repeating that until I turn blue in the face. Not like it matters. But I'm hoping that the because I really hope that she doesn't. No. The state effectively conceded instruction error. None of this is harmless. It goes to who decides what options legally exist and how youth must be considered. If she's tried as a child, she's tried as an adult. Miller parole procedure, even assuming arguendo that Carly could have legally been sentenced to life without parole, which we don't concede, the court failed to hold a Miller complaint hearing before determining Carly's eligibility vel non for a parole-eligible life sentence on count 1, and it delegated the parole question to the jury, something Mississippi law and Statute 97 do not permit. As to count 2, life without parole sentence is wholly improper under Graham v. Florida and its progeny, as Graham prescribes life sentences for any non-murder convictions. Here's the thing. Okay, even if you get the life without parole for count 2 overturned, she still is life without parole in count 1. Like, prejudicial and improper closing arguments by the state. Mississippi law forbids inviting juries to speculate about parole because it injects arbitrary factors into sentencing. See Williams. Here, the prosecutor suggested that if Carly received a parole-eligible sentence, she could be out in as little as a year, stating, "We cannot guarantee if she will stay there 1 year or 10 years." An assertion that is not only patently false, it also is misleadingly reframed the stakes. The prosecutor also attempted to instill fear in the jury by suggesting if they allow parole, they may end up sitting next to Carly in a theater, among other places. That's not instilling fear. That's being honest. Like, she unalived her mom. I mean, once you unalive one person, isn't it just numbers from there? Like, once you show that you have no regard for human life, isn't it just numbers? I mean, let's be honest here. People who unalive other people have no regard for human life. So if they have no regard for that person's life, why do they have regard for what makes you think they're going to have any regard for your life? I don't see it. And this coming from someone who's worked with someone who was in prison for second-degree unaliving. Got out and became my patient eventually. So I've had conversations with someone who unalived somebody, and I still hold that value or hold that opinion. So All right. This is a clear violation of the golden rule in closing arguments. The prejudice is manifest. The jury promptly asks, what is life without parole, years-wise? That question confirms parole became a focal point of deliberations, precisely the harm Williams warns against, and warrants the reversal of the sentences, at minimum, a new sentencing proceeding. Part 2 of appellant's brief addresses overall trial fairness. From the outset, the court announced it would grant no continuances. Fair. This court does not continue cases. Fair. And there was no reason for a continuance. There was none. You had no justifiable reason. You submitted documents. I saw the documents. They didn't pass the smell test. And enforced a September trial date at all costs. And this is what happens when things are taken out of context, like this right here. Within that posture, the court compelled psychiatric examinations and wholesale disclosure of defense-held medical records before any Rule 17.4b notice and without Rule 12.2 findings, short-circuiting the rules and tilting strategy to the state. That order violated the text and sequence of Mississippi Rules of Criminal Procedure and raised serious Fifth and Sixth Amendment, I'm assuming 14th and 4th Amendment concerns with Mississippi constitutional parallels, including the act of production problem. The resulting prejudice, loss of timing, forced disclosure, and the state's head start cannot be undone. You also missed the deadline for a bunch of shit, and the judge called you out on it. All right, footnote 8. The Constitution prohibits the imposition of life without parole sentence on a juvenile offender who did not commit homicide. A state is not required to guarantee the eventual freedom to a juvenile offender convicted of a non-homicide crime. What the state must do, however, is give defendants like Graham some meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation. Here's my thing. They used a case that literally does not have the part they cited. I'm not sure of the whole entire case, but the part they cite does not help their case any. The Constitution prohibits the imposition of a life without parole sentence on a juvenile offender who did not commit homicide. Well, guess what? Okay, even if that second count, the attempted unaliving, goes away, she still has life without parole. So you just wasted her money. I just take comfort in the fact that baby Squid will never disalive from God, I hope so. Some days I wonder. Because yesterday she kneed me in the jaw while trying to use me as a human jungle gym. Because before she goes to sleep at night, she goes into these crazy, almost like she's sundowning, like a dementia patient. And she goes, right before she crashes. And it's a whole lot of, pain in this area, generally speaking. It's more of me going like this and telling her to stop. In short, the cumulative effect of these rulings implicated multiple constitutional protections and substantially compromised Carly's right to a fair trial. Other evidentiary abuses of discretion, allowing Counselor Rebecca Kirk to summarize Crime and Punishment over objection of defense counsel on relevance and prejudicial grounds, was a clear abuse of discretion. I mean, was it though? And Jeffrey, thank you for the $5 super chat. Remembering 8 EMTs, 60 police officers, 343 firefighters, and 2,997 civilians, and the numerous friends and family, businesses, freedom, and innocence lost. Yeah, and not only their lives, but it changed the way we live our entire lives, and the way our children will live their lives, and their children, God forbid we're still here, will live their lives. Relief requested, vacate Carly's sentences, including life without parole on count 2. Remand sentencing under 97-3 with a Miller compliant hearing after proper notice. Are you running, Daddy? An opportunity to be heard and or clarify that Carly's life sentences are parole eligible pursuant to new amendments. Oy, oy, oy. Alternatively, and independently reverse and remand for a new trial based on the cumulative constitutional and rule-based violations, suppressing any fruits of the improperly compelled psychiatric processes, and directing further proceedings before a different judge. Do I think that this girl was failed by the system? It should have been helped better with her mental health issues? Of course, we have a huge mental health issue in this country. And but we also have a problem with providers not taking the fact that people are children into account and trying to treat them like little adults. The medication thing and switching her medications and not monitoring her daily is bugging me. And would that have changed anything? I don't know. But would I be willing to bet that it would change something? I'm curious. And it's one of those, I'm not sure how to feel about this. And this is one of the reasons that this is an interesting case to cover, because it brings up a lot of rabbit hole questions, like treating children with mental health issues. How do we go about that safely? Is there alternatives to medication? How do we get kids to talk to us about their mental health issues? It's it's one of those damned if you do, damned if you don't kind of situations. To the extent any errors identified herein were not preserved by contemporaneous objection, the court should review them under the plain error doctrine because they are obvious, affected substantial rights, and implicate. Sorry, I can't read that without laughing because I'm like, this is the catch-all. This is the if we effed up and didn't do our jobs as appellate lawyers, use this rule as the catch-all to find anything that we didn't. It's like it's one of those things of like, this is the shitty lawyer's guide to writing a motion. Like leaving them uncorrected would seriously affect the fairness, integrity, and public reputation of judicial proceedings. Alternatively, and independently, any failure to raise or properly preserve these issues below constituted ineffective assistance of counsel under Strickland v. Washington. The record is sufficient to resolve the claims on direct appeal, or if the court deems further development necessary, the matter should be remanded for an evidentiary hearing. Here's the argument. Let me get my water for this one. Issue 1, trial court committed reversible error by giving the sentencing instructions to count 1 and 2 that were improper under Mississippi Code. The trial court erred when it instructed the jury that they had an option to sentence Carly to life without eligibility for parole in counts 1 and 2. This is plain error and requires the court to vacate Carly's sentences of life without eligibility for parole for those counts and to remand this case for her to be lawfully sentenced in accordance with that statute, the controlling statutory provision at the time of Carly's trial and conviction. Notwithstanding that Carly's trial counsel did not object to the giving of these instructions, that's a problem. It's plain error because the sentences of life without the eligibility of parole is in conflict with the construction of Section 97-321 of the Mississippi Code, controlling the sentencing statute in question. Here's the thing. As they mentioned above, they were talking about juveniles. Just because she's a juvenile doesn't mean she's subject to the juvenile statutes when she's tried as an adult. Hung Hero, thank you for the $5 super chat. Weaning off ADs after over a decade, taking them was rough. and it was done over months. Just switching meds without support is malpractice. And she was weaned off. They were tapering down one and tapering up the other. So it's like it's just what happens at the same time. So you have to worry about how the side effects from one and the side effects of another now at the same time. It's, I don't know. And everybody's different. And that's our problem too. A medication will not affect everybody the same. So to just check on her or to not monitor her, maybe every day is an overkill but it's a child. At least check in by phone every day or have her parent be documenting. As far as we know, her mom wasn't documenting anything about how these were affecting her, or Carly wasn't documenting daily. Like, it's almost like keeping a headache journal of how you're doing on this medication. Does it help? Does it not? Kind of that stuff. And there was no record of that. And it's just, maybe it's just me and my clinical background on how I interpret things. But with kids and medications, there's no room for fuckery. There's no room for interpretation. You got to get shit figured out, and you have to monitor them, because you can't leave kids to their own devices. I'm sorry, even teenagers. Like, how often did you do shit and not tell your parents? Like, let's be honest. If my parents are watching, you didn't hear any of this. But how often did we do shit without our parents, or what we thought our parents didn't know? Just saying. Just saying. So if we did it, why aren't kids these days doing it? Or what makes us think that kids these days are any better than we were? Hey, General T. Hello, Warriors. Hope you're having a decent day today after the horrible event happened yesterday. Yep, remember to tell the people in your lives you love them. I love y'all. Love you too. Like that annoying uncle that you just can't get. No, I'm kidding. Hey, General. In 2024, the Mississippi legislature substantially amended Statute 97. The amendment became effective July 1st, 2024. For purposes of comparison and contrast, we've included the following table. Prior and effective July 1st, every person shall be convicted of first degree, shall be sentenced by the court to imprisonment for life in the custody, except as otherwise provided for a juvenile offender in subsection 2, every person who is... See, and here's the thing. This takes into account that she is being charged as a juvenile. She is not being charged as a juvenile. She's being charged as an adult. Therefore, juvenile offender doesn't that could be argued that a juvenile offender doesn't matter because she's being charged as an adult. So anything for a juvenile offender does not apply to her. Just one of them loopholes that, oh, she's a juvenile. Yeah, but she was not being charged as a juvenile. So therefore, any statute relating to a juvenile no longer applies to her. If I was a lawyer, that's how I'd argue it. But like I said, I just like to nitpick shit. And I like to nitpick and find the loopholes and the errors. And, that's part of why I wanted to be a lawyer when I was little. But I didn't like public speaking. Every person who is A, convicted of first degree shall be sentenced by the court to imprisonment for life in the custody of Department of Corrections. B, convicted of second degree shall be imprisoned for life in the custody of Department of Corrections if the punishment is so fixed by the jury in its verdict after a separate sentencing proceeding. If the jury fails to agree on fixing the penalty at imprisonment for life, the court shall fix a penalty of not less than 20 and not more than 40 years. C, convicted of capital shall be sentenced to your unaliving. 2, to imprisonment for life in the state penitentiary without parole, or 3, to imprisonment for life in the state penitentiary with eligibility for parole as provided in Section 47, a whole bunch of stuff. 2, for the purposes of this section, juvenile means a person who has not yet reached the age of 18 years at the time of the commission of the offense. Here's the thing. Here's the thing. Here's the thing. This is... Are these with people being charged as children, or are these people being charged as adults? Because there's a difference. And just because you're underage, you are charged as an adult, all the statutes that will apply to juveniles do not apply to you. And Gail, happy birthday to your hubby. It's the day that's never forgotten. Yeah. B, a juvenile offender who's convicted of first degree after July 1st may be sentenced to life imprisonment if the punishment is so fixed by the jury. If the jury fails to fix the penalty at life imprisonment, the court shall fix the penalty not less than 20, not more than 40. I mean, it just says life imprisonment. It does not say with the possibility of parole. I mean, right here, may be sentenced to life imprisonment if the punishment is so fixed by the jury. It does not say anything about without parole or with parole. Whereas this says without parole or with eligibility for parole. So it literally says it in there. I mean, it just says life imprisonment. It does not specify. It does not specify. And C, a juvenile offender who's convicted of capital, doesn't care. A juvenile offender who's convicted of first degree or capital prior to July 1st and who is entitled to a hearing under the subsection doesn't apply to us. And then 2, every person prior to July shall be convicted of second degree, shall be imprisoned for life. And yeah. I mean, I tend to agree with the judge on this one. It's the jury's discretion. And in order to properly give the jury what they should do, it's their discretion. You have to let them know it's their discretion. So I'm not seeing exactly what the issue that they're arguing. I'm not seeing what the problem is. But maybe that's just me. Maybe that's just me. Underscoring this reversible error is the fact that the state, in its closing argument in the sentencing phase, stated to the jury, we'd ask that she be sentenced to prison without the possibility of parole. Once again, that's typical of a lawyer to ask for a specific sentence. I've seen it before, and I've never seen anybody have a problem with it. And if the jury, or if the judge or the defense attorneys had a problem with it, why didn't they object? Just saying. Looks like the jury gets to decide, and it's not a problem. Yeah, just because the jury didn't decide your way does not mean that and I'm hard on the state because, the state and the judge are on the same team at the end of the day. They're both actors for the state. So, it is. The state further commented on parole to the jury and implied that if sentenced to her life with eligibility for it, that would be an unknown how much time Carly would actually serve in prison, and upon release, she would be a danger to society. That's not illegal to say. Sorry. And you don't know how much time. When they're eligible for parole, you don't know how much time they're going to serve. Freaking look at Ruby Frankie. She got 12 years. She may be out in half of that. For what she did, that woman should be in prison for life. Although Carly's trial counsel stated to the jury in its argument as to sentencing, you have 3 options: life without parole, life with parole, or you can let the judge make the determination. Such a statement is contrary to the legislative intent to the new provisions. rule of lenity. If there's ambiguity in the language of subsections 2b and c above, it must strictly construed by the appellate court with any doubts to be resolved in favor of the accused. I mean, it doesn't sound like there's ambiguity in any of that language. Could be wrong. Y'all tell me what you think. For those of you on replay crew, you let me know what you think, because I don't think in that statute that we read there was much ambiguity, if at all. This is a principle deeply embedded in our law. The governing precedent dates back well over a century. Ooh, case from 1909, Stewart v. State. Even the state in its response to Carly's motion for a new trial, recognized that the jury instruction at issue was improper, stating that out of an abundance of caution, the state filed jury instructions which allowed the jury to consider life with the possibility of parole. Yeah, oh my God, this is when appellate lawyers argue against themselves. This is just how I'm reading it. They argued against themselves. Like, the state literally said, out of abundance of caution, we'll allow you to choose life. We'll let you know that you get the choice. They could have just kept that information from the jury. Hey, living life, how are you? You have exciting news? Oh no, yay. If this was error, it was error that weighs in favor of the defendant. I don't think I read that, and I don't think they said that the jury improper was unfair. I think we can go back and look, but that's not what I believe they said. Like, I'm just you ever look at something and you're like, I know I read that and that's not how I interpreted that? Let's see. July 31st. Nope, I don't have it. I know I read it and it's probably saved somewhere else. But it's just one of those situations where I'm like, I know that's not the way I interpreted that. Like, notwithstanding the generosity of the state in looking out for Carly, the error is much more fundamental than allowing the jury to decide if life versus life with or without parole is as demonstrated in the arguments beginning with issue 2 above. Negative implication canon. The expression of one thing implies the exclusion of others. Scalia, reading law, the interpretation of legal texts. Recently, the State Court of Appeals addressed the application of this canon in Beal v. State. When the legislature expanded the attempt statute in 2013 and enacted a new subsection focusing exclusively on attempted unaliving, it pointedly did not include the requirement of an overt act in subsection 1. And so, even if the language of the statute were not plain and unambiguous, our precedent reminds us that where a statute enumerates and specifies the subject or things upon which it is to operate, it is to be construed as excluding from its effect all those expressly mentioned or under a general clause. This common rule of statutory construction is expressio, a Latin phrase, which translates as expression of the one is exclusion of the other. Therefore, we are all compelled to find that the legislature, in using the language of an act in the attempted unaliving subsection 2, as opposed to the overt act language of subsection 1, did not require the description of an overt act in the indictment for attempted unaliving. And this is why these statutes are written so damn complicated. I feel like there's so much better ways to write things that are so much clearer than the way they're written, but they're written like this on purpose. I just feel like they're written like this on purpose. Yay! Your case is being investigated. One of the places is stating to shut down its location for fraud, abuse, neglect, and malpractice. Nice. Because the legislature did not include a requirement to describe an overt act in an indictment under the attempted unaliving statute, we hold an indictment for this crime does not require the description of an overt act. As a result, we find the indictment of this case was sufficient. Here, hey, Snipe Hunter. When the legislature amended the sentencing statute for unaliving in 2024, it expressly included a jury option to sentence a juvenile convicted of capital after July 21st, 2024 to life without parole in subsection 2C. However, the legislature excluded this jury option for juveniles, once again, convicted of first degree after the same date in the immediate proceeding of subsection 2B. Juveniles. This is one of those things of like juveniles. She was not. This is where legally it could get a little hairy. The law describes a juvenile as anybody under 18. However, even though she was under 18, she was 14 at the time, she was tried as an adult. So if I was the state making an argument, I would talk about the fact that that implies that she was tried as a juvenile. She was not tried as a juvenile. She was tried as an adult. So all statutes referring to her as a juvenile don't apply. That's what I would do. I mean, I commend the appellate lawyer for bringing this up because he keeps bringing it up, the fact that she's a juvenile. He keeps mentioning it like it's gonna matter. In my opinion, juveniles are only subject to being treated like a juvenile if they're charged as a juvenile. When you're charged as an adult, all juvenile statutes say bye-bye to you. Carly's jury should not have been given the seriously flawed sentencing instructions for counts 1 and 2, as the jury lacked the authority to even consider life without the eligibility of parole in this case. Had the legislature intended to empower a jury to sentence a juvenile found guilty of first degree after July 1st to life without parole eligibility, it would have expressly stated in subsection 2B, but she was not charged as a juvenile, and that's the biggest problem I have with this. And I'm interested to see if this goes to oral arguments, if they even take this case. I think they will take this case. Because of the notoriety and the attention that it got, I think they will take this case. However, I'm very curious to see what they do with that juvenile and her being charged as an adult versus being constantly referred to as a juvenile in here. Sorry, Carly, you unalived an adult. You did adult things. You were charged as an adult. Because it did not negative implication canon instructs that this option must be excluded. Language is important. From consideration as a sentencing option for any juvenile convicted of first degree after July 1st. Related statutes canon. Statutes in pari materia, once again, a Latin phrase that I don't, are to be interpreted together as though they were one law. Interpretation of legal texts, page 252. Section 97 governs the sentencing of attempted murder. It provides every person who shall design and endeavor to commit an act which, if accomplished, would constitute an offense of unaliving. But then, they have the actual hyperlink. That's nice. But shall fail therein. Side note, I wish that every PDF document like this would have a link to the case law every case law would be hyperlinked, because how interesting would that be? And how much easier would that be to find the case law and actually read the full case law, not only for us, but for judges. Even though judges have access and probably can get to it a hell of a lot quicker than I can, it would be hyperlinked, and therefore I could easily see right then and there if the case they're talking about is, yeah, this could help you, or you just cherry picked a passage that made your case sound good. Or shall be prevented from committing the same, shall be guilty of attempted unaliving, and upon conviction shall be imprisoned for life in the custody of the Department of Corrections, if the punishment is so fixed by the jury in its verdict after a separate sentencing proceeding. If the jury fails to agree on fixing the penalty at imprisonment for life, the court shall fix the penalty of not less than 20 years in the Department of Corrections. A harmonious interpretation in the body of statutory law relevant to Carly's sentences in counts 1 and 2 suggests that, just as she was unlawfully sentenced to life without eligibility of parole for first degree, count 1, she likewise was unlawfully sentenced the same for attempted murder conviction. When the legislature enacts multiple statutes in pari materia, that is, upon the same subject, this court generally will read the statutes together and interpret them harmoniously. In this case, those statutes are that Latin phrase, insofar as the proper sentence for Carly should be life with eligibility of parole. While the legislature did not amend 97-1-1 contemporaneously with its 2024 amendment of 97-3-21, as discussed above, to reach any other conclusion would violate absurdity doctrine. State of New Mexico versus Montano, when invoked, the absurdity doctrine, that's a good name for it, gives the judicial branch the power to avoid an absurd result. I mean, I'm kind of liking the name of that. To construe otherwise, that is, Carly must be sentenced to life without parole eligibility for the attempt conviction in count 2 would be an absurd result, as it would be harsher sentence than the one for actual completed unaliving in count 1, which should be properly be life with parole eligibility. I mean, a provision may be either disregarded or judicially corrected as an error if failing to do so would result in a disposition that no reasonable person could approve. I mean, just, Issue 2, Carly's sentence of life without parole as to count 2 is categorically unconstitutional. Oh, all right. The jury effectively sentenced to Carly life without possibility of parole. Not only was the jury improperly given that option pursuant to the plain reading of the unaliving statute at issue, but the sentence of life without parole for attempted unaliving is unconstitutional pursuant to Graham v. Florida. In Graham, the defendant, Terrence Jamar Graham, was charged at age 16 with armed burglary and assault or battery and attempted armed robbery, not unaliving. He pled guilty under a plea agreement in December 2003 and was placed on probation. But following new offenses and a probation violation, Florida trial court in 2006 sentenced him to life without parole on the armed conviction, a burglary conviction for 15 years imprisonment for attempted armed robbery. Once again, there's a difference between burglary and unaliving. There's a big why does that dude look familiar? What's that dude look like? He's law enforcement. I'll post a picture of it later, but I'll post a picture of it. But that dude looks like he's law enforcement. Hey, Lynn, had to step away from the news for a bit yesterday. It was too much. Yeah. I did do a live stream this morning that was about an hour where it was just me venting, talking, and saying my unfiltered thoughts. And my unfiltered thoughts about the reaction, not necessarily the person at large. I had a problem with the reactions of people, not necessarily the person who actually did it. We have a whole set of issues with him, but, you know, um, so I did upload that I edited some stuff out and re-uploaded it so that it would be monetized. Uh, but that's if you need a place to vent, that would be a good place to go. There was lots of different opinions in there. So, we don't live in an echo chamber on this channel. But this is also why we are going back to regularly scheduled content, because we need a break, and hey, Amos girl. Yeah, that's it. Compassion is gone in the country. Yeah, and I might upload some other stuff too once more information comes out and things like that. But I tried to record a video last night and I stared at my computer and I'm like, I don't know what to say. In considering the constitutionality of the life without parole sentence, the U.S. Supreme Court held that Eighth Amendment prohibits sentencing a juvenile offender to life without parole for any non-homicide offense. Okay, but so vacate her second offense. She still got life without parole for the unaliving of her mother. According to the court, the Constitution prohibits the imposition of a life without parole sentence to a juvenile offender who did not commit homicide. A state need not guarantee the offender's eventual release, but if it imposes a sentence of life, it must provide him or her with some realistic opportunity to obtain release before the end of that term. Was it a 30-06? Because that's what I had heard earlier, but this is one of the reasons that I don't want to talk about facts of the case until facts actually come out, because right now it's all a bunch of speculation. But I watched that video probably 100 times looking at the trajectory, and someone had decent aim. Actually, because that actually hit what I believe is center mass and ricocheted, but that's my personal opinion. But back to the topic at hand before we get sidetracked on that. That'll be a stream for another day, maybe a Saturday night stream where I can drink a beer, because there's a whole bunch of different rabbit holes we can go down with that. But this person that you sent me the picture of looks like law enforcement. We're former military, which, The court emphasized that juveniles are categorically less culpable than adults because their immaturity, vulnerability to outside influences, and greater capacity for change. As such, sentencing a juvenile to life without parole for a non-homicide crime makes an irrevocable judgment that the child is incorrigible. Interesting choice of words. Determined that it's constitutionally impermissible at the outset. Instead, states must provide juvenile offenders with a meaningful opportunity to obtain release based on demonstrated maturity and rehabilitation, though they are not guaranteed eventual release. The court concluded that a juvenile offender who did not commit homicide may not be sentenced to life without parole because such sentence denies hope, rehabilitation, and chance for redemption. I mean, even if count 2 gets vacated, I don't think count 1 will. I think count 1 will be upheld. So, in Manuel v. State, Florida 2nd District Court of Appeals vacated the life without parole sentences of a 13-year-old convicted of robbery with a firearm and attempted first degree, holding that Graham v. Florida applies to attempted unaliving. The Manuel court rejected the argument of the state that Graham does not apply to Mr. Manuel because his convictions for attempted unaliving should be considered homicide offenses, not non-homicide offenses. I mean, that's an interesting case and an interesting statement right there. Do y'all get that? Manual court rejected the argument of the state that Graham does not apply because to Mr. Manuel because his convictions for attempted murder should be considered homicide offenses. So the state was arguing that even that a homicide or attempted homicide should still be seen as a homicide offense, even though they didn't succeed. I'm tempted to agree with the state on that one. That's just my personal opinion, because that's to me, attempted unaliving is just an unaliving that you sucked at. You couldn't actually be good at what you tried. So, Hey Tammy, how are you? The court reasoned that homicide, by definition, requires the death of another human being, and therefore attempted murder is a non-homicide offense. I mean, I get it. This is one of those, fine lines where I get it, I just don't like it. Stating that under the definition of homicide, it is necessary for the act to result in the death of a human. Relying on Graham, the Manual Court concluded that life without parole for juveniles who commit non-homicide crimes is unconstitutional, no matter how serious the offense. The court emphasized that while attempted murder is grave, life is over for the victim of unaliving, but for the victim of a non-homicide crime, life is not over and is normally not beyond repair, and thus categorically falls within Graham's protection. In Carly's case, the jury was improperly presented with the option of sentencing her to life or life with the possibility of parole for count 2, attempted unaliving, which by negative implication resulted in a de facto sentence of life without parole. That sentence cannot stand under controlling precedent. The holdings in Graham v. Florida and Manuel v. State clearly prescribe the sentence of life without parole for Carly's attempted murder conviction. Graham established the categorical rule that juveniles may not receive life without parole for any non-homicide offense. But I'm curious, were those people, and I keep repeating this, but it's so important to me, and it's a major point to me, were these people tried as children, juveniles, or adults? There's the main kicker, and they never mention it. They never mentioned that even though these are children, they were tried as adults. So just because Carly was tried as an adult, they never make that point. And once again, if I were her attorneys, once again, I'm not, never claimed to be. Unlike some people, I've never been mistaken for an attorney, and I don't want to be. If you know, you know. I want to know in these other cases, if I were her attorney, and if those other cases, those juveniles were tried as adults, I would bring that up. I would bring, even though these are juveniles, these people were tried as adults, just like Carly, who was tried as an adult. Having that crossover would lament to me as the judge on the appellate court that, okay, these cases are juveniles who committed certain crimes and were held to adult standards, but still treated like juveniles in the eyes of the statute. There's the $1 million question, because there's a huge difference to me in the eyes of the law, in the eyes of the statute, and how I interpret the statute. If it's juveniles who are charged as juveniles, or juveniles who are charged as adults. Those are two completely separate how I interpret things. And Tammy, thank you for the $2 super chat. Hey Carly, denied. Sit down. Yeah. I'm hoping so. And Manuel applied that rule directly to the attempted, emphasizing that attempted, by definition, is a non-homicide offense because no life is taken. And accordingly, any life without parole sentence imposed in this case as count 2 is unconstitutional and must be vacated. Beyond categorically bar against life without parole for non-homicide offenses, Carly's case also raises a distinct constitutional error. The trial court failed to conduct the individualized Miller hearing required before imposing any life sentence on a juvenile convicted of homicide. And that's another thing. Do they have to complete that hearing if she's being tried as an adult? There's that $1 million question, and no one in here has answered it. If I were her lawyers, and that the fact that she was tried as an adult didn't matter in the eyes of the statute, she's still a juvenile, I would have said, despite her being charged as an adult, the juvenile statute still stands. The fact that they're not mentioning that sometimes in these appellate briefs, it's with 75 pages of information, because we're on page 39 of 75. So we've actually done pretty well in 2 hours. However, the fact that they're not bringing that up, to me, is like a major red flag. I don't know about anybody else, but I think we're going to get through issue 3, and then we'll do the rest of this tomorrow afternoon. Because I've got to see how long. Oh, yeah. We'll get through this, and then we'll figure out what we Issue 3, the trial court erred by not conducting a Miller-compliant hearing to determine eligibility, val non, for life without possibility of parole as to count 1 and or count 2. This issue proceeds on the premise that by operation of Mississippi's parole statute, the life sentences imposed on count 1 and count 2 are parole ineligible. As explained in issue 1, we maintain the legislature intended life imprisonment for a juvenile convicted of first-degree murder to include parole eligibility, and attempted murder argued in issue 2. Life without parole for non-homicide crimes for juveniles is categorically unconstitutional. As assumed arguendo, this court disagrees. We turn to the trial court's failure to provide and apply a constitutionally adequate individualized Miller analysis under Miller v. Alabama, Montgomery v. Louisiana, and their Mississippi progeny. Framed as due process and Eighth Amendment problem, the court should review de novo whether the trial court provided the constitutionally required individualized Miller hearing and adequate notice opportunity to be heard. See Chandler v. State. And even though the trial counsel did not lodge a contemporaneous objection, the court should reach the issue under the plain error doctrine, because the constitutional deficits as sentencing implicate fundamental rights and fairness of the proceeding. Brown v. State. As in Brown, the error is not harmless under Chapman v. California, since the state cannot show beyond a reasonable doubt that conducting an impromptu sentencing phase without meaningful notice or mitigation did not contribute to the outcome. Accordingly, the sentence must be vacated and the case remanded for a Miller-compliant resentencing with proper notice and a meaningful opportunity to present mitigation. In the alternative, the court should vacate the sentence and impose a parole-eligible sentence. In Carly's case, immediately after the jury returned from deliberations and the trial court announced a verdict of guilty as to all 3 charges and polled the jury for unanimity, the court moved straight to the sentencing phase. They did. The court, all right, ladies and gentlemen, with you having returned a verdict and the indictment, will now proceed with the sentencing phase of trial. The state of Mississippi may call its first witness. Although the judge did ask first the state and then the defense whether they wished to call witnesses, and both declined, the parties were given no meaningful notice or time to marshal witnesses or otherwise prepare for sentencing proceedings of this magnitude. This is not the court's problem. This was her lawyer problem. And this is what happens when you have a DUI lawyer and a personal injury attorney trying a murder case. No offense, but they're good at what they do. Maybe good at what they do. I don't know if these two are. But there's a reason that there's differences in who tries what cases and what area of law you practice. When you've practiced a certain area of law, just like when you've practiced in a certain area of OT, it's very hard to change and go from geriatric to pediatric because things are different and you may not be good at it because it's so different. So going from she had one of her lawyers was a DUI lawyer and the other one was a personal injury attorney, both trying an unaliving case. I don't know if that was the best idea. I don't know if they knew what to object to. If it sounded like they should have objected to this and they didn't. That's not a court problem. That's a lawyer problem. And you can't blame the court for the failings of your lawyer, Bruce. FYI, this is for you. This message is for you, Lynette, John, anybody who's wanting to listen. You can't blame the court for the failures of your lawyer. You should have hired a better lawyer. Proceeding in that fashion denied Carly a real opportunity to present mitigation and fell short of the constitutional framework required by Miller v. Alabama, which demands an individualized hearing that meaningfully considers youth and its attendant characteristics before a juvenile may be exposed to life without parole, reserved only for the rare juvenile whose crime reflects permanent incorrigibility rather than transient immaturity. She was charged as an adult. I could see this if she was charged as a juvenile, but she was not. She was charged as an adult. The trial court's immediate pivot from the jury's guilty verdict to sentencing, asking the state and then the defense if they wished to call witnesses on the spot, did not satisfy the constitutional requirement for a separate Miller hearing. And its progeny require more than a perfunctory inquiry. They mandate a distinct proceeding affording a juvenile defendant a meaningful opportunity to present mitigation evidence, addressing the hallmark features of youth, Montgomery v. Louisiana, stating a hearing where youth and its attendant characteristics are considered is necessary to separate those juveniles who may be sentenced to life without parole. Parker v. State, that was not done in Carly's case. By collapsing sentencing into the trial's conclusion and denying defense counsel adequate time to prepare and summon witnesses, the court deprived Carly of the individualized assessment that Miller demands. Accordingly, her sentence must be vacated and the case remanded for constitutionally sufficient Miller hearing. While the defense did not object to this sequence of events, that's a problem. That's your lawyer problem. That's not a judge problem. That's not a prosecution problem. That's defense attorney problem. And that's why you should be careful of who you hire as a lawyer. And hey, Janet, I'm glad you find it interesting. This was sent to me yesterday, and it was like, oh, we got to talk about this. We respectfully submit that the trial court's failure to conduct a constitutionally adequate Miller proceeding is reviewable as plain error. Oh, no. Mr. Squid sent me a picture of the little from the living room. She is passed out. Oh, no. She's going to be up all night. Mississippi appellate courts may notice an unpreserved error where the trial court deviated from legal rule. The error is plain, and it affects substantial rights, particularly where a fundamental constitutional protection is at stake. Damn, I love it. See Connors v. State, Brown v. State, because the parole statute makes juvenile life sentence functionally life without parole. The court had an affirmative duty under Miller v. Alabama and Montgomery v. Louisiana to provide an individualized sentencing in which youth and its attendant characteristics are meaningfully considered before imposing a parole-ineligible life term. Short-circuiting that process by pivoting to sentencing immediately after the verdict and inviting witnesses without affording the defense time to marshal mitigation, both contravened the governing legal rule and substantially affected Carly's Eighth Amendment rights. He's good to go. He's doing okay. Thank you for asking. Nor Did the hearing comport with due process? First, due process requires notice and opportunity for a hearing appropriate to the nature of the case, i.e., a meaningful chance to be heard at a meaningful time in a meaningful manner. See Langford v. Idaho. Reversing where a defendant lacked fair notice and opportunity to prepare a precise sentencing exposure, the court ultimately imposed. Speck v. Patterson. Sentencing that turns on new outcome determinative findings requires adversarial protections. Gardner v. Florida. It is now clear that the sentencing process, as well as the trial itself, must satisfy the requirements of the Due Process Clause. Here, the court pivoted directly from the verdict to sentencing, asking on the spot whether the state or defense wished to present witnesses. Because Mississippi's parole statute makes a juvenile's life sentence parole ineligible, that immediate turn functionally exposed Carly to life without parole without affording reasonable notice or time to marshal Miller mitigation, records, lay witnesses, and qualified expert testimony. That procedure violated core due process guarantees. I mean, did it really though? Like, there's just certain things where I'm like, did it really? But did it really? I mean, I appreciate the argument, but at the same time, I'm kind of like, this is hinky. Second due process violation is compounded by the Eighth Amendment framework itself. Montgomery v. Louisiana explains that a Miller proceeding must give effect to this substantive rule by providing a hearing where youth and its attendant characteristics are considered as sentencing factors, which is necessary to separate those juveniles who may be sentenced to life without parole from those who may not. Quoting Miller v. Alabama, the same day unprepared sentencing phase deprived Carly of the meaningful opportunity. Due process does not permit a de facto life without parole outcome to rest on the record created without advance notice and a fair chance to gather and present Miller evidence. In Presley v. State, the defendant Presley was caught shoplifting steaks at a Kroger. When confronted by store staff, he displayed an open pocket knife and left. He was later arrested and convicted of armed robbery. After the jury declined to fix life imprisonment, the judge held a brief, bifurcated sentencing. The state introduced certified copies, of 2 prior felonies. The court confirmed a PSI had been provided. The defense offered no mitigation, and Presley was sentenced as a habitual offender to 40 years without parole under that statute. Despite the PSI and the judges offered to hear mitigation, the Mississippi Supreme Court held the sentencing record was inadequate and vacated the sentence, remanding for a fuller hearing. The court emphasized that even when the defense counsel has not developed the record, the trial court must consider all facets, background, and record in a sentencing hearing in order that a just and proper sentence may be imposed, and should require counsel to present any mitigating circumstances on remand, vacating and remanding for an additional sentencing hearing and resentencing. All right. So that footnote, although the record does not reveal the exact time of day of the sentencing phase of the trial began, we would point out that it was on a Friday afternoon. Okay. Presley squarely supports our complaint that Carly's sentencing phase was too cursory and occurred without meaningful time to marshal mitigation or witnesses. If the Supreme Court had vacated a habitual offender sentence even through a PSI, though a PSI existed and the defense declined to put on a mitigation, it follows a fortiori that Carly's immediate on-the-spot proceeding without advance notice, preparation time, or a developed mitigation record was inadequate. Presley confirms the trial court bears an affirmative duty to ensure a complete, informed sentencing record. That duty is even weightier in a juvenile case requiring the individualized analysis mandated by Miller Montgomery. But she was tried as an adult. There's the kicker. They keep bringing up juvenile. She was tried as an adult. So all of these things that apply to a juvenile, I believe the judge was like, they don't apply to her because she's being tried as an adult. there's the mindset shift between the trial court and the appellate brief. And that's I think their whole appeal is based on the fact that she's a juvenile. And I think it's going to fail because at the end of the day, even though she's 15 years old, she was tried as an adult. They're bringing up these like armed robbery cases. I'm sure these armed robbery cases and these other cases they're bringing up, these children were tried as children. And that's where my head is wrapping around like all of this. I cannot get past the fact that they keep bringing up that she's a juvenile, but she was tried as an adult. And when someone is tried as an adult, I've said it before, and I know I'm beating a dead horse, but when someone is tried as an adult, do all the statutes as children that apply to juveniles, like they're trying to bring up here, don't apply because she's not a child in the eyes of the law that she was being charged with. Like, if she was being charged with first-degree unaliving as a juvenile, I could see this working. But the fact that she was not charged as a child, she was charged as an adult. Therefore, Miller hearings don't need to be handled for adults. Like, those don't need to be present for adults. So that's probably why the judge didn't do it. I'm just a thought. And if this goes to oral arguments, because the crux of their argument is she's a juvenile. And I don't know how the appellate court's going to see that, but I would see that as she was tried as an adult. So your whole 20 pages of BS is no longer applicable. So you wrote this whole thing and you charged her family. Let's be honest, remember that. How many hours did this take to write, and how much was the family charged for writing this and submitting this? When you know that it's not going to go anywhere because she was tried as an adult and not a child. My brain just works differently than other people's. I don't know if anybody else thinks like me, but I keep focusing on that because it's all I can think about with every argument that they try to make. It's a juvenile case. She was not charged as a juvenile. She was charged as an adult. I need to hear Flash Fan's opinion on this. The remedy Presley ordered vacatur and remand for full, properly developed sentencing hearing is exactly what we seek here. A Miller-compliant resentencing after proper notice, time to prepare, expert assistance, and presentation of comprehensive mitigation. The Presley court stated, we recognize there are cases, even when the appellant and his attorney failed to prepare a complete sentencing record, where the trial court must consider all facets, background, and record in a sentencing hearing in order that a just and proper sentence may be imposed. Alternatively and independently, the absence of an objection only underscores the ineffective assistance under... I like how they're basically throwing her trial counsel under the bus. Absence of an objection only underscores the ineffective assistance under Strickland v. Washington. Competent counsel would have, one, insisted on a separate Miller hearing or a continuance once it became clear that life would be a parole ineligible, had qualified adolescent development forensic psychology experts to address the Miller factors, and 3, gathered school, medical, correctional, and family history mitigation and lay witnesses to address each Miller factor. Failing to do so falls below an objective standard of reasonableness given the centrality of Miller. Evidence in juvenile life without parole determinations. This is not juvenile court, and Mississippi's burden-shifting framework, placing the onus on the juvenile to show Miller considerations bar life without parole. And C. Jones v. State, Cook v. State. Footnote 12. Prejudice is equally plain. With proper notice and a developed Miller record, there is at least a reasonable probability the sentencer would have either rejected a parole-ineligible life sentence on count 1 or fashioned a parole-eligible outcome consistent with Miller, Montgomery, and Mississippi law. The reasonable probability sufficient to undermine confidence in the result satisfies Strickland's prejudice prong, especially where the court proceeded without the very mitigation Miller requires before a juvenile may be deemed among the rare offenders warranting life without parole. Nor can the failure seek time to marshal mitigation, witnesses, and evidence be characterized as strategy. It was omission, not tactics. The proper remedy is to vacate the sentence and remand for a full Miller-compliant resentencing after adequate notice and preparation, with expert assistance and opportunity to present comprehensive mitigation. The footnotes. In this regard, virtually all lay witnesses who could have offered character and background evidence for Carly were excluded at trial. It is unclear whether the court would have permitted them to testify in mitigation. In any event, by moving immediately to a truncated sentencing, the trial phase prohibition effectively carried forward and foreclosed their mitigation testimony. And 12, see Gregg Gets Life, Jackson Jambalaya, Blogspot. Last visited that date, September 8th. Oh yeah, this is the last one we're going to be doing because we'll do the other ones tomorrow. Additionally, Mississippi Rules of Criminal Procedure 26.3 authorizes the court to order present tense investigation and requires that any report be furnished to the parties at least 48 hours before sentencing. Rule 26.4 contemplates holding the sentencing hearing only after the parties have had opportunity to review and address the report. In a case of this magnitude, where a juvenile faces a potential parole-ineligible life term because she was charged as an adult, let's reiterate, charged as an adult, the court abused its discretion by declining to order a pre-sentence investigation and by pressing ahead without continuing the proceedings to allow completion and disclosure of a PSI. The state may argue that Jones v. Mississippi supports the life without parole sentences based on the holdings that no separate findings of permanent incorrigibility is required. However, Jones did absolutely nothing to dilute Miller or Montgomery. To the contrary, Jones reaffirmed that the court may impose life without parole on a juvenile after giving genuine, individualized consideration to youth and its attendant characteristics. I do think this is very well written, though. This is a very easy read. Nothing is too hard for me to understand. Some of the wording, my brain doesn't want to function, but that's a me problem, not an appellate brief problem. But I still don't see this working because they keep bringing up the juvenile aspect. It's like she was not charged as a juvenile. It may work because I could be completely off base because, once again, not a lawyer. These are just my layperson opinions on the law. And how lawyers operate and how to tell good ones from bad ones. You don't have to be a lawyer. As someone pointed out in my comments, I needed to be a lawyer to tell what a good one was. No, you don't. No, you don't. Thanks, AT1. That's my whole point. Charged as an adult, ergo her penalties are as an adult, not a juvenile. So whenever they're bringing up juvenile in these statutes, she's not charged as a juvenile. As the majority held, Miller mandated that only a sentencer follow certain process considering offender's youth and attendant characteristics before imposing life without parole sentence. Discretion is therefore constitutionally only if it's meaningful exercise through that process. That process never happened here. Carly was sentenced immediately upon conviction, like an adult, mind you, without the pre-sentence investigation, without time to marshal mitigation, without expert testimony, blah, 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 without lay mitigation witnesses. The court conducted no on-the-record individualized assessment of the hallmark features of youth or Carly's capacity for rehab. Based on the foregoing argument, we respectfully submit this court must vacate the sentence and remand for a Miller-compliant resentencing that provides reasonable advance notice, permits defense, expert, and lay mitigation, and allows the court to make an individualized determination on a complete record. If the court deems the due process claim unpreserved, It remains reviewable as plain error given the fundamental nature of the right and the function of life without parole at stake. And page 30 or 47 of 75 is where we are going to leave off. And we will continue issue 4 through 10 tomorrow, because we are 2 hours and 20 minutes into this. And I think after 2 hours, the brain kind of gets a little mushy. Things start to not make as much sense. And reading just gets a little bit more, I get a little more frustrated with reading after about 2 hours. But I think we made it 47 out of 75 pages in 2 hours. I think we did pretty damn good. For those of you who are still here and haven't hit that like button, please do it. Please share this stream. I appreciate all of you guys who hang out with me on these non-hot topic streams. They're not the going thing for the day. They are not everybody's favorite, but this is an important case because she was only 14. 14. Oh, I didn't know about that. But whatever. It's not that. It's more of my brain can only tolerate, and my butt can only tolerate sitting in this chair for 2 hours at a time. And also like just reading, 2 hours is where my attention span just kind of like starts to go in la la land. And y'all know I have a short attention span to begin with. So the fact that my already short fly of an attention span gets shorter, plus for people on Replay Crew, 3, 4, 5 hour streams are really hard to watch on Replay Crew. I don't like watching streams over 2 hours. I get bored. Like I said, I get bored easily. So I try to run my channel in the sense of understanding how y'all like to watch things. And after 2 hours, 2 hours of listening to one person talk is like, I apologize for yesterday. I didn't do a stream yesterday. Spawn and I are rescheduled for next week. Tomorrow we will be finishing this document and then possibly doing either any updated What the Hales documents that come out. I haven't checked the docket today. I try to save money and only check it Monday, Wednesdays, and Fridays because, even checking it is hard sometimes. I might do a weekend update because there's a couple of cases that have kind of small updates. Not a super long stream. I'm also trying to get more information about Charlie Kirk and everything. And when I compile some evidence, because I have theories and conspiracy theories, so I need to consult with my conspiracy theory people and see what they think, because y'all, this is just some not kosher. Like, something's not kosher. I will be compiling more people and more evidence of people. Okay, I've never been the cancel culture, get fired over what people say on the internet, because people are stupid. People say stupid shit all the time that we don't agree with. Most of the time, you just let it go. But when people are celebrating the death of somebody, and I didn't watch Charlie Kirk all the time. I don't watch a lot of people all the time. But like, the man disagreed with you got a lot of people on a lot of things, but he never once advocated for violence. So the fact that somebody shot him, most likely because he didn't agree with his politics, we have problems with that. So I might do some calling of businesses to get people fired, especially that bitch that lives in Milwaukee and works with children. I see you. I know who you are. So I'm not going to say your name, but you showed up on my Facebook. So you other people who are larger than me have put your name out there. I'm not going to quite yet because I want to investigate. But I will. I'm not one to usually call for people getting fired, but there are some people who definitely deserve some instant karma. Like, I don't know, losing your job, especially when you have a job that you generally have a contract, I don't know, as a teacher. Um, and I'm sure your online presence is monitored and you have a stricter what you can and can't say outside of work hours. Gotta get I'm looking to, you know, but that's like I'm so sick of being nice to people who don't care. Like I saw something today and it was like a woman that was like, I'm usually not this kind of person, but I want justice and I want vengeance. And somebody on the left was like, see, y'all are, y'all are evil. Y'all are saying you're not good people. Y'all are saying that you want vengeance, blah, blah, blah. Y'all are calling for violence. One, she never called for violence. She said that she's having thoughts that she never has because she isn't the type of person to usually have those thoughts. However, my response was reacting to violence and incitement of violence are two different things. There you go, changing more definitions to fit your narrative. Just because you change the definition of, and also, nobody goes around starting stuff, but like, if you start something, it, yeah, we've been nice, and all this time we've been nice, we've been peaceful. Look where it gets us. But like, look, if we were those kind of people, there you would have seen rioting last night, and you didn't. You saw a bunch of people pissed off on the internet talking about how pissed they are, but you don't see us going out and burning shit down and stealing shit and destroying people's personal property because we're mad. It's because we're all adults and we have consciences. We don't, destroy shit. But before we go, I just want to remind you of like shit like this. Friendly reminder. Ah, da, da, da. Friendly reminder. And all those people who wanted to burn down Teslas and burn Tesla dealerships because they don't like Elon. I'm tired of being nice. I'm tired of hypocrisy. And when all of a sudden we say we're tired of being nice, all of a sudden we're these evil people. It's no, the projection is real, bitch. The projection is real. All right, so she's not coming up on there we go. So Rosalind, it will be going live in a little while. Doing her deconstruction of a conspiracy. Yes, mostly peaceful protests. Yes. So I've redirected y'all over there. She's going live at 6. She got about half an hour. I will see you guys over there. She is doing part 12 of Deconstructing a Conspiracy, Otter Creek edition. And I believe Venom might be with her, as they normally are together. Not sure. Don't quote me on that, but she has been the last few times, so I would assume that she's with her on this one. Anyway, y'all have a great day, and remember, life is precious. Life is not guaranteed. Everybody, hug your kids a little tighter. Don't be afraid to tell people you love them, because tomorrow is not promised, as proven by yesterday's events. Bad things happen to good people. Stay safe, and I'll see you guys on the next one.